Hello everyone. I've been asked to address a couple of questions, but first of all I'll introduce myself. I'm Nicola Ross, I'm a Senior Lecturer in the School of Law, and my primary research interest is actually children's participation in decision making, and that includes decision making in family law matters. So I wanted to talk first of all about the status of the Convention on the Rights of the Child in Australian law. International treaties and conventions, such as the Convention on the Rights of the Child, which is the convention that has probably been signed by more states in the world than any other convention. In fact, only 2 states haven't signed and ratified the Convention on the Rights of the Child, and those states are the United States of America and Somalia. The rest of the world has ratified this convention in one form or another. But the real question that you need to think through is, to what extent does this convention have force of law in Australia? Now, conventions and other international treaties are not like domestic law. They are not binding on judges who are determining what the law is in Australia. However, they are persuasive. So the Convention on the Rights of the Law, which was ratified in 1990 by Australia, basically is appended to the Act which establishes the Human Rights Commission. It is, however, not enacted into law in Australia, and therefore it is not binding law in Australia. However, it is recognised in a number of Australian statutes, such as the Family Law Act. The Family Law Act has 4 objects, and in 2011 amendments to the Family Law Act actually included the Convention on the Rights of the Child as a 4th object under section 60B subsection 4 in the Family Law Act. And that means that it is going to be taken account of to some extent, and it certainly is taken account of in many ways in family law, for instance. So the first thing is to understand that the convention itself is not law in the same way in which the Family Law Act is, for instance, but that it has an influence and it's aspirational, but when you have it included as a principle, then it's likely that the court will attempt to a great extent to meet the aspirations that are included in the Convention on the Rights of the Child. The second thing that I was asked to talk about was the issue of children's participation in decision-making under the Family Law Act, and in fact under other acts such as the Children and Young Persons Care and Protection Act, which is the Child Protection Act for New South Wales. The Convention has a very large number of articles, and in fact it's quite complex to get to know, and even I, who've been working with this convention for some time, I certainly couldn't recite all the articles, which are like the sections, if you like, of the convention, and I wouldn't know how to interpret many of them. But what I can say to you is that there are certain general or key principles that are important in understanding the convention as a whole. And 2 of those key principles are Article 3, which is the best interest principle, that decisions that are made in relation to children should be made in the best interests of children. And secondly, Article 12, which is also known as the participation principle, that when decisions are made about children's lives, then they have a right to express a view and to have that view taken into account in decisions that are made about them in relation to their age and maturity at the time. But what is really clear is that the children should be able to express a view, and that should be considered in decisions that are made, even if that is coloured and conditioned in relation to their age and maturity. One of the important questions is how Article 3, which is about the best interests of children and making sure that adults and professionals think about what is best for children when they're making decisions, that impact upon their lives. And secondly, how Article 12, which is about children's right to express a view and have that considered as part of that decision making, how they actually work together. Well, in many situations they're understood to conflict, to actually be at odds with each other. But I would suggest that some of the better theoretical work around this, and in fact the Committee on the Rights of the Child, which is a committee set up under the Convention on the Rights of the Child, have it right in suggesting that Article 3 and Article 12 need to work together, so that you can't actually determine what is in the best interests of a child without ensuring that a child is given an opportunity to express a view, and that view is taken into account as part of the process of making that decision. So there's a lot more things to think about when you're thinking about the Convention on the Rights of the Child and children's participation, such as what are the conditions that children might need in order to make, to be part of a decision-making process, to participate in that. And the Committee on the Rights of the Child have provided a very good document in 2009, which was called the General Comment Number 12 on the child's right to be heard. So if you want to think more about that, I would suggest that that particular document is a very, very useful place to start. And it sets out quite clearly this interaction between making decisions in children's best interests and the need to ensure that children are supported to participate in those decisions. Thanks. Daniel, just turn it off.